This is part 29 as far as our lecture series is concerned, and we have started discussing information to the police and their power to investigate. During course of our last lecture we have learned that if the nature of the offense is cognizable, anybody can set criminal law into motion by following the procedure which is laid down as far as subclause 1 of section 154 of the Criminal Procedure Code is concerned. And then the importance of subclause 2 and subclause 3 that we have taken into consideration. So, if the nature of the offense is cognizable, police officer has got right to start with the investigation without any order from the court of law as per subclause 1 of section 156 of the Criminal Procedure Code is concerned. So there may be FIR or there can be investigation in the absence of FIR as per subclause 1. The first information or information which is first in point of time can be lodged with any police station, but which is the police officer or which is the police station which has got power to start with the investigation is not made very clear in the Criminal Procedure Code, but subclause 1 of section 156 has got reference to chapter right from 177 up to 189 of the Criminal Procedure Code, namely jurisdiction of the criminal code. So with which we shall be dealing in during course of our lecture series. Now, once officer in charge of a police station or investigating officer wants to start with the investigation, the first and the foremost step is that whether there is FIR or there is no FIR, he has to submit a report to the magistrate as far as section 157 of the Criminal Procedure Code is concerned, and the steps that are required to be taken by the magistrate or which are likely to be taken by the magistrate are as per section 159. And now the investigation, which is collection as per subclause H of section 2, starts on the part of the investigating officer. So now there may be chance or possibility that he may arrest a suspected person or accused person, and now section 57 comes into operation which says a person arrested accused of an offence is required to be produced before a magistrate within a period of 24 hours excluding the period of journey. Hence there cannot be detention of such a person beyond this period of 24 hours unless order or sanction is given by the court of law, hence he is required to be produced. Now if he is produced, the maximum number of days for which he can be detained at the police station is 15 days. It is never at a stage, but this is what is known as a police custody. And then after police custody, if at all he is not released on bail, then he can be detained in the jail in the magisterial or judicial custody as per section 167 of the Criminal Procedure Code is concerned. With this now, when after expiry of this period, namely the police custody or magisterial custody which is granted, such a person for the purpose of further detention is required to be produced before a magistrate as far as section 170 is concerned. And lastly, we have learned when collection of the evidence is complete and the investigating officer is ready as far as his case of an accused person is concerned, he will submit his report as per subclause 2 of section 173 of the Criminal Procedure Code, and that way. So these are the stages into which the investigation will result into. And then section 167, which clearly lays down that when there is no evidence against an accused person, then as per section 169, such a person is released, and hence the question of proceeding further against such a person doesn't arise as per the provisions of the Criminal Procedure Code. And hence, if you just go through section 169, which was section 169 says, if upon an investigation under this chapter it appears to the officer in charge of the police station that there is not sufficient evidence or reasonable ground of suspicion to justify the forwarding of the accused to a magistrate, such officer shall, if such a person is in custody, release him on his executing a bond with or without sureties, as such officer may direct to appear, if and when so required, before a magistrate empowered to take cognizance of the offence on a police report and to try the accused or committed for trial. So this is a release of accused when evidence is deficient is laid down as far as section 169 is concerned. Now, during this, as we go on learning this part, you will come to know the police officer has got power to record statement of the persons, and this is for the purpose of recording statement of a person who knows who has got knowledge regarding commission of an offence, or who is aware regarding commission of an offence. For that, police officer has got power to require attendance of a witness, and that is made very clear as far as section 160 is concerned, which says any police officer making an investigation under this chapter may, by order in writing, require the attendance before himself of any person being within limits of his own or any adjoining station, who from the information given or otherwise appears to be acquainted with the facts and circumstances of the case, and such person shall attend as so required, provided that no male person under the age of 15 years or a woman shall be required to attend at any place other than the place in which such male person or woman resides. So this is, and then examination of a witness by police is made very clear as far as section 161 to be read with section 162 code.
Now, this also says that statement to police is not to be signed by the person, and what is the importance of this statement as far as evidence is concerned. Now, this is not at all a substantive evidence as in case of FIR, and this statement which is made to the police or which is recorded by the police during the course of investigation can be only used for the purpose of contradictions as far as section 145 of the Indian Evidence Act is concerned. Now, this is regarding the procedure that is required to be followed as far as recording of the statement during the course of investigation is concerned. With this now, there may be a situation where the accused person who is arrested by the police, is ready and willing to confess the act, namely offence which is committed by him. Now, even though there is confession by an accused person to the police, that is not admissible because that is hit by section 25 of the Indian Evidence Act, and hence how to make use of such confession is the question. For that, whenever you want to learn the law relating to confession, you have to, substantive law is laid down right from section 24 up to section 30 of the Indian Evidence Act. And in order to know judicial confession, which is a substantive evidence, namely which is a proof of the facts stated therein, this part of the chapter, namely section 164, makes it very clear as to who can record the confession, when he can record the confession, what is the procedure that is required to be followed as far as recording of the confession is concerned, and rest of the details are laid down as far as section 164 is concerned, which reads as follows. Any metropolitan magistrate or judicial magistrate may, whether or not he has jurisdiction in the case,
record any confession or statement made to him in the course of an investigation under this chapter or under any other law for the timing in force or at any time afterwards before the commencement of the inquiry or the trial, provided that any confession or statement made under this subsection may also be recorded by audio, video, electronic means in the presence of the advocate of the person accused of an offence, provided further that no confession shall be recorded by a police officer on whom any power of magistrate has been conferred under any law for the timing in force. The magistrate shall, before recording any such confession, explain to the person making it that he is not bound by law to make a confession, and that if he does so, it may be used as evidence against him. And the magistrate shall not record any such confession unless, upon questioning the person making it, he has reason to believe that it is being made voluntarily. If at any time before the confession is recorded, the person appearing before the magistrate states that he is not willing to make the confession, the magistrate shall not authorize the detention of such person in police custody. At any such confession shall be recorded in the manner provided in section 281 for recording the examination of an accused person, and shall be signed by the person making the confession, and the magistrate shall make a memorandum at the foot of such record to the following effect: I have explained that he is not bound to make a confession, and that if he does so, any confession he may make may be used as evidence against him, and I believe that this confession was voluntarily made. It was taken in my presence and hearing, and was read over to the person making it, and admitted by him to be correct, and it contains a full and true account of the statement made by him, which is required to be signed by the magistrate. Any statement other than confession made under subsection 1 shall be recorded in such manner hereinafter provided for the recording of the evidence as is, in the opinion of the magistrate, best fitted to the circumstances of the case, and the magistrate shall have power to administer oath to the person whose statement is so recorded. The magistrate recording a confession or statement under this section shall forward it to the magistrate by whom the case is to be inquired into or tried. So this is as far as the recording of the confession is concerned. The manner in which confession, whether it should be in the question answer form, whether the confession should be in the form of narrative. For that, I mean, this is the time for us to refer to, along with section 164, you have to refer to section 281 of the Criminal Procedure Code. We shall be dealing with this section again in detail at the time when we deal with section 313 of the Criminal Procedure Code during the course of the trial, where we will understand the manner in which confession is required to be recorded. But from the point of view of understanding the recording of the confession, it is must that you have to read section 164 along with section 281 of the Criminal Procedure Code. Now, if there is no compliance with the provisions of section 164 or section 281, what is the effect of it? And that is made very clear as far as the chapter to which I have referred to in the past, namely irregular proceedings, where we have to read section 463, which says, if any court before which a confession or other statement of an accused person is recorded or purporting to be recorded under section 164 or section 281 is tendered or has been received in evidence, finds that any of the provisions of such sections have not been complied with by the magistrate recording his statement, it may, notwithstanding anything contained in section 91 of the Indian Evidence Act, take evidence in regard to such non-compliance, and may, if satisfied that such non-compliance has not injured the accused in his defense on the merits, and that he duly made the statement recorded, admits such statement. The provisions of this section apply to Court of Appeal, reference and revision. So, if this is the time for you to refer to section 91 of the section 91 of the Indian Evidence Act, which speaks about exclusion of oral by documentary evidence. So when there is a documentary evidence, the court will not allow oral evidence. That is made very clear, but this is an exception to section 91 of the Indian Evidence Act. Now the court has also got power. The officer in charge or investigating officer has also got power to carry out search, and this search is as per section 165 of the Criminal Procedure Code, which is in the absence of search warrant. And then if you go on reading this section, it says, whenever an officer in charge of a police station or police officer making an investigation has reasonable grounds for believing that anything necessary for the purpose of an investigation into any offence which is authorized to investigate may be found in any place within the limits of police station of which he is in charge or to which he is attached, and that such thing cannot in his opinion be otherwise obtained without undue delay, such officer may, after recording in writing the grounds of his belief and specifying in such writing so far as possible the thing for which search is made, search or cause search to be made for such thing in any place within the limits of such station. A police officer proceeding under subsection 1 shall, if practicable, conduct the search in person. If he is unable to conduct the search in person and there is no other person competent to make the search present at the time, he may, after recording in writing his reasons for so doing, require any police officer subordinate to him to make the search, and he shall deliver to such subordinate officer an order in writing specifying the space to be searched and, so far as possible, the thing for which search is to be made, and such subordinate officer may thereupon search for such thing as such place. The provisions of this code as to the search warrant and general provisions as to searches contained in section 100, with which we have dealt in the past, so far as may apply to search mates. Copy of any record made under subsection 1 or subsection 3 shall forthwith be sent to the nearest magistrate empowered to take cognizance of the offence, and the owner or occupier of the place search shall, on application, be furnished free of cost with a copy of the same by the magistrate. Now, with this there may be a situation where investigation is required to be carried out beyond the territorial limits of India, and for this purpose there are two sections which come into operation. Section 166A speaks about letter of request to competent authority for investigation in a country or place outside India, and section 166A capital A reads as follows: notwithstanding anything contained in this code, if in the course of an investigation into an offence an application is made by the investigating officer or any officer superior in rank to the investigating officer, that evidence may be available in a country or place outside India, any criminal court may issue a letter of request to a court or an authority in that country or place competent to deal with such request to examine orally any person supposed to be acquainted with the facts and circumstances of the case, and to record his statement made in the course of such examination, and also to require such person or any other person to produce any document or thing which may be in his possession pertaining to the case, and to forward all the evidence so taken or collected or authenticated copies thereof or the things so collected to the court issuing such letter. The letter of request shall be transmitted in such manner
as the central government may specify in this behalf. Every statement recorded or document or thing received under subsection 1 shall be deemed to be evidence collected during the course of investigation under this chapter. Whereas section 166 capital B deals with letter of request from a country or place outside India to a court or an authority for investigation in India. And it says, upon receipt of a letter of a request from a court or an authority in a country or place outside India, competent to issue such letter in that country or place for the examination of any person or production of any document or thing in relation to an offence under investigation in that country or place, the central government may, if it thinks fit, forward the same to the Chief Metropolitan Magistrate or Chief Judicial Magistrate or such Metropolitan Magistrate or Judicial Magistrate as the case may, appoint in this behalf, who shall thereupon summon the person before him and record his statement or cause the document or thing to be produced, or send a letter to any police officer for investigation, who shall thereupon investigate into the offence in the same manner as if the offence had been committed within India. All evidence taken or collected under subsection 1 or authenticated copies thereof or the things so collected shall be forwarded by the magistrate or police officer as the case may be to the central government for transmission to the court or authority issuing the letter or request in such manner as the central government may deem fit. Now, this is regarding the collection of evidence by the police during the course of investigation. Now, we have learned that we have dealt with that the investigating officer is expected to maintain a diary and in the diary he shall make mention of all the steps that are taken by him for the purpose of recording of the collection of the evidence, every step that is taken by him. This is what is known as a case diary. When somebody goes to the police station and sets criminal law into motion by giving information which reveals commission of a cognizable offence, then the officer in charge of a police station will reduce into writing substance of such information in a police station diary. This is the diary to which I mentioned is what is known as case diary, or this is also known as a special diary. Now, section 172 deals with diary of proceedings in investigation, which says every police officer making an investigation under this chapter shall day by day enter his proceedings in the investigation proceedings of the investigation in a diary, setting forth the time at which the information reached him, the time at which he began and closed his investigation, the place or places visited by him, and a statement of the circumstances ascertained through his investigation. The statement of witnesses recorded during the course of investigation under section 161 shall be inserted in the case diary. The diary referred to in subsection 1 shall be volume and duly paginated. Any criminal court may send for the police diaries of a case under inquiry or trial in such a court and may use such diaries not as evidence in a case but to aid in such inquiry or the trial. Neither the accused nor his agent shall be entitled to call for such diaries, nor shall he or they be entitled to see them merely because they are referred to by the court, but if they are used by a police officer who made them to refresh his memory, or if the court uses them for the purpose of contradicting such police officer, the provisions of section 161 or section 145 as the case may be of the Indian Evidence Act shall apply. So the case diary can be used by the police officer for the purpose of investigating officer when he is in the witness box for the purpose of refreshing his memory, or that can be used by the court of law for the purpose of contradiction. So for that I mean
this is the time for you to refresh your memory or have reference to section 159, 160 and 161 of the Indian Evidence Act. Now, during the course of investigation, if the case is regarding an rape, then medical examination of the victim of the rape is required to be carried out, and section 164A of the Criminal Procedure Code comes into operation, which says where during the stage when an offence of committing a rape or attempt to commit rape is under investigation, it is proposed to get the person of the woman with whom the rape is alleged or attempt to have been committed or attempted examined by a medical expert. Such examination shall be conducted by a registered medical practitioner employed in a hospital run by the government or local authority, and in the absence of such practitioner by any other registered medical practitioner with the consent of such woman or of a person competent to give such consent on her behalf, and such woman shall be sent to such registered medical practitioner within 24 hours from the time of receiving the information relating to the commission of such offence. The registered medical practitioner to whom such woman is sent shall without delay examine the person and prepare a report of his examination giving the following particulars, namely the name and address of the woman and of the person by whom she was brought, the age of the woman, the description of a material taken from the person of the woman for DNA profiling, marks of injury if any on the person of the woman, general mental condition of the woman, and the material particulars in reasonable detail. The report shall state precisely the reasons for each conclusion arrived at. The report shall specifically record that the consent of the woman or of the person competent to give such consent on her behalf to such examination had been obtained. The exact time of commencement and completion of the examination shall also be noted in the report. The registered medical practitioner shall, without delay, forward the report to the investigating officer, who shall forward it to the magistrate referred to in subsection 173 as a part of the document referred to in clause A of subsection 5 of that section. Nothing in this section shall be construed as rendering lawful any examination without the consent of the woman or any person competent to give such consent on her behalf. With this now, once the investigation is over, the report is required to be submitted to the magistrate who has got right to take cognizance of an offence, and this is made very clear as far as submission of this investigation results into submission of report as far as section 173 is concerned. And section 173 says every investigation under this chapter shall be completed without unnecessary delay. The investigation in relation to a rape of a child may be completed within 3 months from the date on which the information was recorded by the officer in charge of the police station. Subclause 2 says, as soon as it is completed, the officer in charge of the police station shall forward to a magistrate empowered to take cognizance of the offence on a police report, a report in the form prescribed by the state government stating the names of parties, the nature of information, the names of the person who appear to be acquainted with the circumstances of the case, whether any offence appears to have been committed and if so by whom, whether the accused has been arrested, whether he has been released on his bond, if so whether with or without sureties, whether he has been forwarded in custody under section 170, whether the report of the medical officer of the woman has been attached where investigation relates to an offence
under section 376, 376 capital A, 376 capital B, 376 capital C or 376 capital D of the Indian Penal Code. The officer shall also communicate in such manner as may be prescribed by the state government the action taken by him to the person, if any, by whom the information relating to commission of the offence was first given. Where a superior officer of the police has been appointed under section 158, the report shall, in any case in which the state government by general or special order so direct, be submitted through the officer, and he may, pending the orders of the magistrate, direct the officer in charge of the police station to make further investigation. Whenever it appears from report forwarded under this section that the accused has been released on his bond, the magistrate shall make such order for the discharge of such bond or otherwise as he thinks fit. When such report is in respect of a case to which section 170 applies, the police officer shall forward to the magistrate along with the report all documents or relevant extracts thereof on which the prosecution proposes to rely other than those already sent to the magistrate during investigation. The statements recorded under section 161 of all the persons whom the prosecution proposes to examine as its witnesses. If the police officer is of the opinion that any part of any such statement is not relevant to the subject matter of the proceeding, or that its disclosure to the accused is not essential in the interest of the justice and is inexpedient in the public interest, he shall indicate that part of the statement and append a note requesting the magistrate to exclude that part from the copies to be granted to the accused, stating his reasons for making such request. Where the police officer investigating the case finds it convenient to do so, he may furnish to the accused copies of all or any of the documents referred to in subsection 5. Nothing in this section shall be deemed to preclude further investigation in support of an offence after a report under subsection 2 has been forwarded by to the magistrate, and where upon such investigation the officer in charge of a police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed, and the provisions of subsection 2 to 6 shall, so far as may be, apply in relation to such report or report as they apply in relation to a report forwarded under subsection 2. With this now, at times there may be a situation that there was a delay as far as lodging of FIR was concerned, and then if you, as we have tried to understand the evidential value of FIR, similarly, if there is a delay, then the court should be very cautious, because it may be concocted theory unless there is a delay is properly explained by the prosecution accordingly. Details, there may be also a situation where the commission of the information which reveals commission of an offence may be that of a cognizable as well as non-cognizable offence. And then if you read section 155, then subclause 4 says, where a case relates to 2 or more offences of which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offences are non-cognizable accordingly. So with this now, during last lecture I referred to one section, namely, if the death has taken place under suspicious circumstances, then the power vests in the executive magistrate for the purpose of carrying out inquest in order to find out cause of death. As per section 176,
If the death of the person has taken place in police custody, executive magistrate shall conduct an inquiry for the purpose of finding a cause of death as far as the death that has taken place when he was in the police lockup is concerned. With this now, the next part with which we shall be dealing is right from section 177 up to 189, which deals with jurisdiction of a criminal court. And when we talk about jurisdiction of a criminal court, we shall we shall deal with territorial or local jurisdiction, and the further part with which we will continue as far as our next part of the series of lectures is concerned.